Good morning, everyone. I am Monalisha Padhi. I am a legal intern at LEXIS and Company, and I am currently in third year of BBA LLB, and I am pursuing it from Bharati Vidyapit New Law College. So my today's topic is marital rape, and the purpose for this video is to create awareness about marital rape and why does it need to be criminalized in India. When we talk about marital rape, domestic violence have to be taken care of. Domestic violence in India is an entrenched problem and it has only been exacerbated in recent years. According to the NCRB report 2019, about 70% of women in India are victims of domestic violence. One such manifestation of this domestic violence is marital rape. Marital rape is basically the act of forcing your spouse into having sex without proper consent. It is an unjust yet not uncommon way to degrade and disempower women. Today, marital rape has been impeached in more than 100 countries, but unfortunately, India is only one of the 36 countries where marital rape is still not criminalized. Even though many legal amendments have been done in criminal law for the protection of women, the non criminalization of marital rape in India undermines the dignity and human rights of women. We shall now discuss that what is the status of marital rape in India. The definition of rape, which is codified in Section 375 on the Indian Penal Code, includes all forms of sexual assault involving non consensual intercourse with a woman. We have a exception in Section 375, exception 2, that is non criminalization of the marital rape. It exempt unwilling sexual intercourse between a husband and a wife over 15 years of age, but above that it is not criminalized. As per current law, a wife is presumed to deliver perpetual consent to have sex with her husband after entering into marital relation. The concept of marital rape in India is the epitome of what we call an implied consent. Marriage between a man and a woman here implies that both have consented to sexual intercourse and it cannot be otherwise. We'll now see that what are the constitutional and legal rights against the marital rape. So we will discuss the doctrine of coverture. Non-criminalized nature of marital rape emanates from the British area. The marital rape largely influenced by and derived from this doctrine of merging the woman's identity with that of her husband. At the time of 1860, when the IPC was drafted, a married woman was not considered as an independent legal entity. The marital exception to the IPC definition was drafted on the basis of Victorian patriarchal norms that did not recognize men and women as equals, did not allow married women to own property, and merged the identities of husband and wife under the doctrine of coverture. This marital rape is a violative of Article 14. Marital rape violates the right to equality, which is enshrined in the Article 14 of the Indian Constitution. The exception creates two classes of women based on their marital status and immunize action perpetrated by men against their wives. In doing so, the exception make possible the victimization of the married woman for no reason other than their marital status while protecting unmarried women from those same acts. This marital rape also defeats the spirit of Section 375 of IPC. The purpose of Section 375 of IPC is to protect women and punish those who engaged in inhuman activity of rape. However, exempting husband from punishment is entirely contradictory to that objective, as the consequences of rape are the same whether the woman is married or unmarried. Moreover, married women may actually find it more difficult to escape abusive conditions at home because they are legally and financially tied to their husband. Additional to this is also violative of Article 21. According to creative interpretation by the Supreme Court, rights enshrined in Article 20 include the right to health, privacy, dignity, safe living conditions, among others. In a recent case, State of Karnataka versus Krenappa, the Supreme Court held that the sexual violence, apart from being an dehumanizing act, is an unlawful intrusion of the right of privacy and scarcity of a female. In Justice K.S. Puttaswamy versus Union of India, the Supreme Court recognized the right of privacy as a fundamental right of all citizens. The right of privacy includes decisional privacy reflected by an ability to make intimate decisions, primarily consisting of one sexual or procreative nature, and decision in respect of intimate relations. What are the way forward in this? There are many foreign countries. They have declared the uh, marital rape as a crime, such as the United Nations Declaration on the Elimination of Violence Against Women. It defines violence against women as any act of gender based violence that results in or likely to result in physical, sexual, or mental harm or suffering to women, including threats of such acts, coercion, or arbitrary deprivation of liberty, whether occurring in private or public life. The GS Verma setup in the aftermath of national-wide protest over the December 16, 2012 Delhi gang rape case has also recommended the same. By removing this law, women will now safer from abusive spouses, can receive the help needed to recover from marital rape, and can save themselves from domestic violence and sexual abuse. So, the Indian law now affords husbands and wives separate and independent legal identities, and much jurisprudence in the modern era is explicitly concerned with the protection of women. Therefore, it is high time that the legislature should take cognizance of the legal infirmity and bring marital rape within the purview of rape laws by eliminating Section 377, Section 375, Exception 2 of IPC. Thank you all. That's all for the topic today. Please like and comment on the video, and please subscribe the channel. Thank you.